Hello, everyone, and welcome back to the.universary. Today's first case is out of Thurston County, Washington, which is quickly becoming one of my absolute favorites. The gamut of cases that we see out of Washington are really something to behold. Now, this case, I was tempted to leave it by itself, but there will be another video at the end. This is Andy Hanna versus Todd Hansen. Now, Mr. Hansen is the manager of a development company that purchased property next to Mr. Hanna's property and developed it, including cutting down what is apparently a very wanted tree. And I hope you can hear the quotation marks around wanted because I'm not entirely sure of Mr. Hanna's motives. It kind of feels like he's looking for a payday without a purpose. But you let me know your thoughts in the comments. Hope you enjoy.
Hanna versus Hansen. Mr. Hanna and Mr. Hansen, can I have you each raise your right hand, please? Did Mr. Hanna drop off? Did I lose him? Back. There we go.
It froze and I had problems getting back in, Your Honor.
Okay, we've got you back now. All right. Yeah, I noticed that as I was about to swear you in that your connection seems to have just dropped. Okay, so what I'm about to do is swear you both in, and then Mr. Hanna, as the plaintiff in this case, I'll hear your case first. So can I have both Mr. Hansen and Mr. Hanna raise your right hand, please? And do each of you swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes.
Yeah, I do.
Okay, Mr. Hanna, go ahead.
I had one question, Your Honor. I missed the part before where you were talking about, I guess, the guidelines. So in my statement, am I able to refer to the defendant's table of contents and stuff as well?
Yes. Yeah. I don't know if I was clear about that or not, but if you want to draw attention to the other party's exhibits, you can do that too, just the same way, refer to them by exhibit number, page number.
Well, Your Honor, essentially what happened was that Mr. Hansen, through his multiple LLCs, owned the property or a portion of our property line is adjoined by the property that he owned. And there was a cedar tree that had grown over the boundary between our two properties. Admittedly, it was a small portion of the cedar tree on my property. However, Washington state law says that a tree that's grown over is the ownership is between both of the property owners. You have to have permission to cut down, damage, or cause the tree to die from both property owners before you can do that. So we lost property value. We lost a significant amount of canopy because of the old growth, because of the second growth trees on the development property. The cedar tree's canopy a majority of it was on our side of the property, shaded a lot of it. So we've had to have some consultations for native plant growth. We've also, in addition to that, we've also had to plant native trees. We've had several invasive species that have come from the development and the stormwater retention pond that have crossed over onto our property that we've had to deal with. So there's a couple of issues. One is that 3 different arborists said that we owned a portion of the tree. My personal arborist, I hired Ray Gleason, who owns Cascade Tree Experts, and then both the city's arborist and their consulting arborist both said that I owned a portion of the tree. So with timber trespass in Washington, the award is treble. I believe that I am the only, without my consent or the city taking my property, or the portion of my property the tree is on, through legal means, then the only legal way to have consent to take the tree down would be for me to agree to it. So that's basically the crux of my argument. I have a couple of exhibits that I think should be noted and are important. One is just a picture of Mr. Hansen the day the tree was taken down. Now, he claims that he had nothing to do with the tree taken down. He was both there at the site. That would be exhibit. Let's see here. I believe it's exhibit 4.
4.
And then exhibit 5 pretty clearly demonstrates that there was no structural problems with the tree, especially not any structural problems that were visible from the outside of the tree. It was perfectly healthy. The only problems that would have come about would have been from due to the development's construction, and once again, because the tree is property in common, it would be illegal to kill the tree. And then I got a picture of me sitting on the tree. At that point, this is exhibit 7. At that point, police officers are on scene, 5 of them. And I'm on my property. They are declaring that if I pass this invisible line of the tape, that, or any of us, that will be taken to jail for trespassing. Of course, that wasn't enforced when the tree faller trespassed, although I asked it be, and the excavator also trespassed on my property, the boom and the bucket. Exhibit 8 is just a definition of the trunk from an arborist. So it includes the basal flare, trunk flare, root flare. There's a lot of different things that it's called. But basically, it's what comes out of the ground. And there's no crazy root structure on a nursery tree that, comes out 6 feet away or anything like that. It's just a tree on the ground, on flat ground. So, and then I come to exhibit 9, where Mr. Hansen makes a call to the Olympia Police Department on the day they cut down the tree. He lists himself as the victim of the call. And of course, 5 officers respond. Exhibit 10 is Michelle Bentley with recommendations not to remove the tree, that there is a way to save it. That was actually a discussion in response to an email that I had sent to Leonard Bailey, who's I believe, the Department of Planning Director, Community Planning and Development Director. I sent plenty of emails back and forth. I initially stopped the tree from being cut down the initial time, and explained the situation to the sergeant who was called on scene for trespassing. And he said it was a civil matter. And then he told me that, full disclosure, that he is a personal acquaintance of Mr. Hansen. I'm assuming that exhibit 11, the sergeant, that I didn't include the email address that this is an attachment for. So this is a public, these last 3 exhibits are from public records released from the city of Olympia, but the email is to the sergeant. I'm assuming that it's the acquaintance. I'm not sure. Now, I would like to bring a couple of issues with the contents of Mr. Hansen's, I guess, rebuttal. The first thing I would like to note is that in number 10, under exhibit 10 of his table of contents, it says RCW includes the terms without lawful authority. Not only was the tree on my property as indicated in the survey and municipal application and permit, but I believe that this process provided the intended authority. No tree was cut, no land was cleared, no road was built without all proper notice, applications, and permit procured in advance. First of all, there's the question that's going to be raised as to who owns this property. It was passed through a couple of LLCs. Mr. Hansen is the governor of the, registered as the governor of the LLC that ended up owning it during the construction. But he refers to it as my property there. He was the point of contact given by the city throughout the entire process as the developer. He was there that the day the tree was cut, and he refers to himself as the victim of trespassing. He refers to the property as his. So I think it's pretty clear that, to me, it seems clear that he had ownership and control of the property. It may be the LLCs that he has, passed it from one to the other. He's governor of both, but he had personal control of the property. And a couple of other issues. So the survey record, as far as I know, I haven't seen a survey record that actually indicated the trees to be cut. And I advised Mr. Hansen of the state law prior to the tree being cut down, actually several weeks prior to the tree being cut down. And he chose to take whatever actions and means that he could influence to make it happen. So I guess what he did was he took a gamble that I wouldn't be able to represent myself, or I wouldn't be able to have the resources to get representation, and be able to out-resource him. And he was correct. That was a good gamble. But nevertheless, a portion of the tree was on my property. There are a couple of pictures that he put in. So the civil engineering stuff is not an issue, except for that Mr. Hansen's name, whether listed under a company or a contact, is on every permit. The survey of record, this is exhibit number 6, has an X mark where the tree is. I do not believe that X mark was on the original survey in 2019 or something. But obviously no other trees are listed there. So that X mark is a little deceptive. The center of the X shows the tree completely on his property. And that's not where it is, or where it existed. The tree, there's a couple of exhibits with pictures. Exhibit 8 shows a tape line between 2 posts along the edge of the tree. Now, if that is the actual property line going in the right direction, then I'm wondering what the back corner of my property, why it's been cleared. The picture's taken at an angle that's quite misleading. Although there was some damage to the back of my property, but 6 inches or something on that back corner there. The tree interior is missing a majority of the tree interior. There's a lot of sawdust. The tree did have some internal rot. I believe the most common one is brown scale rot, which is extremely common in mature cedars and does not affect their stability for the most part.
Mr. Hanna, I want to stop you for just a second, because I do want to ask a couple questions, and I'm also going to give you just a couple minutes to wrap it up.
Yes, sir.
So Your the sort of the fulcrum here of your claim is that the tree that was cut was the tree was at least partially growing on your property.
That is correct, Your Honor.
And that depends, the basis of your opinion that that is the case is what?
Is that three arborists said that the tree was on my property. The tree, the base of the tree that they cut off is on my property. I was sitting on my property on the basal root or the basal flare of the tree on my property as they were cutting it over the top of my head. So even according to their survey that day, the tree was on my property. So.
And you're relying, again, correct me if I'm wrong, but this is what I heard, that you're relying on, I'm losing the exhibit number now. There, that's it, number 7. Yeah, you're now, correct me if I'm wrong, like I said, you're relying on exhibit 7, which depicts a piece of red tape as a representation of the property line. And there was another one. Yeah, it was number 7. Yeah, I've got 7. I guess number 6 also shows the same tape line.
Yes.
And number 5 shows that line. All right, now tell me if you know who put that tape line up.
Hansen Construction had that tape line put in, I believe, with GPS technology on the day they cut down the tree. They did not run a line from the corner marker to the corner marker at that point.
And then the other one I was looking for, I was actually one of the defense exhibits that you referred to earlier, number 7, which shows another angle of the same tape line, and it also depicts the tree. So yes, you were relying on that as well.
That and oh, I'm sorry, Your Honor, go ahead.
So you're telling me that that tape line that's supported by a couple of stakes there was put up by Mr. Hansen or somebody acting on his behalf?
That's correct.
Okay, that's what I wanted to understand. Okay, so I don't misunderstand what you were telling me. All right, so Mr. Hanna, why don't you take a couple of minutes here and wrap up your claim, and then I'll hear from Mr. Hansen.
Sure. So the last exhibit that I think is important is number 10. I believe I covered the first lawful authority. The second page of that describes the Washington state law of liability associated with the falling tree. The tree was stable.
Is that defense 10 or plaintiff's 10?
I'm sorry, that's defense 10.
Okay, thank you.
It talks about the owner knowing the condition. It was a perfectly healthy tree. There was no indication of any kind of disease from the outside, according to several arborists. Which then brings you down to the fact that the construction activity was going to damage the tree to the point where it would become unstable. And once again, that's not legal. And if we go down, it specifically says if you plant a tree on your property and it grows onto your neighbor's property, Washington law deems such a tree be jointly and equally owned by you and your neighbor. Punitive damages can be imposed if you deliberately cut down the tree that is in another person's property. Negligent behavior can also lead to damages, and then endangering trees can lead to damages. And I think it's pretty obvious, or to me, it is obvious that the tree had grown onto my property, that he deliberately cut it down, and that when he cut it down, the person that he assigned to cut down the tree was absolutely negligent in their behavior and safety in relation to me and my neighbors.
Okay. All right. I think I understand the nature of your claim. So I will then turn to you, Mr. Hansen, to present your defense to the claim. And then after I've heard from you, I'll make a decision. So go ahead, Mr. Hansen.
Thank you. So as discussed, I am the manager of Tenino Land Company, which owned this property at the time of the construction activities. The permits in reference do list me as manager. Tenino Land Company applied for these permits for the road construction and associated improvements. It took approximately 18 months to review. I don't believe that Washington law allows for managers or employees to be held liable for activities of the corporate entity. Nonetheless, I'm here defending this action. We did have, Mr. Hanna raise concerns about the location of the tree when we began clearing. City of Olympia staff contacted me multiple times. I agreed that if it were possible to save the tree, I would. Michelle Bentley visited the site on 4 different occasions, reviewing our activities. She, in the end, decided that the tree should be removed. The exhibits that you're referencing showing the property line were installed by a licensed surveyor at the time of removal. The property line was staked at multiple points along the common line. Neither myself nor any of my crew working for Tenino Land Company trespassed at any point. Mr. Hanna references a arborist dictionary that defines a root flare. And it says the main stem and bole of a tree beginning at the flare and ending at the highest main scaffold of the branch. What they're defining is where the trunk begins. And again, in the exhibits, it's clear that the entire trunk of the tree is well clear of the property line. There is a portion of a root flare growing onto Mr. Hanna's property, but that is not sufficient to qualify for a common ownership of the tree. Mr. Hanna also references damage or reduction in value to his property. I pulled property records from multiple properties in the area. All of them have a corresponding reduction in value in that time frame, from 21 to 22, more indicative of market conditions and county activities than anything to do with the removal of a tree. Lastly, I believe when I have permits in hand and take every step to comply with all municipal and state code, that I have the right to rely on that permit and the associated reviews at the request of Mr. Hanna by municipal staff. I believe I have a right to rely on that for my company's activities to proceed. This property was subdivided in 1895. Our survey confirmed that subdivision. Municipal staff confirmed the zoning compliance, approved the requested permits, reviewed it multiple times as we were underway, and agreed that we should proceed. And specifically, at the direction of Michelle Bentley, we did remove the tree. Michelle Bentley is city arborist. The tree was dead inside. It would not have remained living, and at some point was going to fall regardless of our activities. But that's speculative. I will reserve any further comment there. But there was no value to the tree. It had no commercial value of any kind and was ground up and hauled away and disposed of. What Mr. Hanna is doing is asking that we misapply a state law to try and achieve some financial gain because he didn't like my project, despite the fact the project was applied for before his ownership began. And for these reasons, I think this case should be dismissed.
Thank you, Mr. Hansen. All right, I think I understand the nature of your defense to the claim as well. And I have had an opportunity to review the exhibits and other documents and statements submitted by both sides. So the record of the claim is, in addition to the testimony that each of you offered, includes the various documents that you've submitted in preparation for your claim and for your defense. All right, I think I can issue a ruling on this based on the evidence presented here. And like many cases that are presented in small claims court, these things frequently come down to burdens of proof. Mr. Hanna is the plaintiff here and maintains the burden to prove his claim by a preponderance of the evidence. In order to do that, I think it takes maybe more evidence or a different kind of evidence than the assumptions that are sort of built into this claim. One is I do not share the level of confidence that apparently both parties, but particularly Mr. Hanna, has presented in where the property line is, specifically in relation to the tree. And I don't think I would have the level of confidence necessary to find by preponderance of the evidence that the tree was growing on the property line without essentially what amounts to expert testimony. In other words, someone like a land surveyor who could say with a level of certainty based on his professional expertise or her professional expertise that the tree was present on the property line. It's very common for parties to run lines, rope lines or tape lines between stakes and believe in their minds, honestly, that is in fact the property line. But in many, many cases, that is not the actual property line to a level of accuracy that's necessary to make that kind of determination. A surveyor could have testified or provided a statement to that effect, but that's not part of the record in this case. The other is that the issue of the tree roots or a flare of root being partially on Mr. Hanna's property line would, as a matter of law, not be enough to establish that the tree was growing on both properties. The law recognizes that a property owner has the right to cut and prune and lop branches and roots that intrude upon their property, which sort of by inverse implication indicates that the presence of roots is not in and of itself enough to legally establish that a tree is growing on a property line. I think that Mr. Hansen's analysis there that some part of the actual trunk or bole of the tree would have to be on the property line in order for that to then create the common interest or common ownership in the tree. Simply the presence of roots that encroach would not in and of itself do that. So I can't find by a preponderance of the evidence that this tree was on the property line and therefore a commonly owned tree. Furthermore, the preponderance of the evidence standard has not been met with regard to either the value of the tree, if indeed the tree had any value, in order to assign any damages if there had been any, nor to, for the same reason, nor to be able to find by a preponderance of the evidence that the property value itself was reduced in any degree in a cause and effect relationship created by the removal of the tree. This is one of those situations that frequently happens where people assume that the thing that happened last was caused by the thing that happened first, which is a correlation, but not a causation. So for all of those reasons, I find that the claim has not been proved by a preponderance of the evidence, and I therefore issue judgment in favor of the defense.
Thank you, Your Honor.
And that will be the judgment of the court. I will sign and execute that judgment, and it'll be available to both parties at the end of the court calendar.
Thank you.
Thank you, sir.
You're welcome.
So, what'd you think of that first case? I really look forward to reading all of your comments and just hearing your thoughts on it. This second case is also from Thurston County, Washington. We have Mr. Haas, who was a subcontractor, who was supposed to do some work in Mr. Frolicker Grimstead's home. And side note, I love the last name, Frolicker Grimstead. I think it's fabulous. Anyway, Mr. Haas says that he did a lot of construction work and was not fully paid for it. Mr. Frolicker Grimstead said that the work was not completed. And so here is this case. Now, check out the last few seconds after Mr. Frolicker Grimstead leaves the court and what Mr. Haas tries to talk to the judge about. And let me know your thoughts on that too. Hope you enjoy.
Most of the time when people, and what's your name, sir?
My name's Riley Frolicker Grimstead.
Riley, I'm sorry?
Riley Frolicker Grimstead.
Got it. And so, these cases, there's a little slot. The amount owing is 4, and then people write stuff in like rent, damage deposit, or anything like that. And a lot of times people will submit things of evidence, and so I can look at before. But all this says is wages of breach of contract, so I don't know anything about this.
Oh,
So Mr. Haas,
Yes, sir.
could you raise your right hand, please?
yes, sir.
You swear to affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You're asking for a judgment in the amount of $3,394.21.
Yes, sir.
And then how is it that Mr. Frolicker Grimstead, am I saying that correctly?
Yes, you are.
Owes you that amount of money?
I had an agreement with him to tape, finish, and texture. I think it was about 210 sheets. I'm not sure exactly the board count number. And we'd agreed on the price of $7,918.27 plus
Okay,
tax.
so you're gonna need to slow down here a little
Oh,
bit.
sorry.
Remember, I'm hearing about all this the first time.
From Chicago.
So if
sorry.
I'm taking notes,
Yes,
you're
sir.
gonna have to speak a little slower.
Okay,
So again, what,
I had an agreement with him to tape, finish, and texture his home. New construction.
he hired you to do this?
Yes, sir.
Okay.
Yes, sir.
And what was the price?
$7,918 and
Okay.
27 cents plus tax.
Okay. And then what happened? Did you do it and you not, well, just tell me what happened.
Well, it came to, so I have to admit, he was really patient. My mom had the lymphoma for the second time. She's in hospice now. So the whole time I was having trouble with the timeline, but he was very agreeable and everything was fine till the very end. I was gonna come sand it and get it textured, and I showed up and he was already sanding it. And he was a little gruff about the finish work, said that it wasn't done, and all it had to be done is sand it, do some touch up, and start texturing. About 2 days work. I knew that he had been patient with me. I offered to give him $500 cash off the deal, and a few hours maybe if he had work in the future, I could give him some help. Because I did feel for him. I know that he wanted it done, and it was taking forever. But couldn't come to an agreement, come to any kind of anything. Couldn't talk to him about it. So I ended up just coming and filing the small claims.
Well,
I got a lot on my plate with my family.
I'm sorry.
I have a lot on my plate at the time. I would have tried to communicate more, but I just didn't.
So
again, he said 7,000, so did he pay you?
Oh, yes, he's paid me 2776 and 2,500 total.
2776 and
Yes.
2,500?
Yes, sir. I didn't do the math for all that, sorry.
Okay.
But the amount owing was 3394.21. And today I even offered a discount on that, but
Okay. But you didn't do everything that you had contracted to do.
well, because once he started sanding
I know
it,
that, but
I
I mean-
can't come in and fix somebody else's work. I was
No.
contracted to sand it, finish it.
Right. But well, let me hear from him.
Yes, yes.
And then, when I think I have a good idea of what I'm gonna hear from him.
Okay.
Can you raise your right hand, please?
Yes.
Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. What's your position on this?
I put together a couple packets. I got pictures, some other info.
Do you have copies for him too?
I do, yeah.
Give him a copy and then give me a copy. It's a good idea to, wow, that's a lot here. Okay, so hang on just a second. So this is the final product of what you finished there, Mr.
Yes, it is. And the last page of pictures are just the flaws that I've been fixing still from Scott's finishing techniques.
Okay, just a minute. So Mr. Haas, I'll come back to you where on the page where it says section not completed or / upheld. Where you
Which page is that? Sorry.
on this one, I don't think he paid it or number, but the thing I got, there was a cover sheet. And then there was a copy of the handwritten contracts.
Right.
And then there was
This one.
checks that you had paid, he had paid
Yes,
about 5,200.
Yes, sir.
76. But then on the page after that,
Gotcha.
there's a list of things that was not completed.
Yeah,
Do
no,
you agree with that?
when I agreed to I didn't sand it because he sanded. Once somebody else starts standing my work and takes over the job, that's a breach as far as I'm concerned. So I did not sand it and I did not texture it. But as far as I scrapped out everything that was in the house except for some minimal drywall I put in his trailer out front. I have a picture of 3 of that on my phone. And I did. I put on three. He says it didn't apply 2 topping coats. I put 3 coats on that. I double boxed it with the 10 and I finished boxed it with a 12-inch flat box. And most of the issues he's showing that in the pictures, sir, are just simply have to be scraped and sanded. I don't see anything horrible except texture. And I didn't apply any of this texture that he's showing.
Okay, give me just a minute.
Yes, sir. 3 pictures of one thing. Sorry.
Mr. Frolic or Grimstead, anything you'd like to say?
I did my best to, I think I pretty much covered everything I felt I needed to get out in here. I don't know if Scott says he has pictures of my trailer loaded with drywall. It's because I loaded it and I scrapped out the house.
All right.
I do have, it's tough to take pictures of flaws in somebody's work, especially, drywall where you're looking at a white wall and you got a bunch of little specks of white on it. I do have a very lengthy video that might show some more of the imperfections and flaws. And it's something that isn't, I guess, common knowledge that, outside the trade of drywall, exactly, what you'd be looking at. But it's something I'm pretty familiar with as a general contractor. And, I witnessed throughout the lots of projects I've worked on. So.
And then how did you come about paying him these 2? Did you get a bill and then pay as you go thing, or how did that work?
So the first check was for the 27 and change, and that was the deposit that he asked for.
Okay. Was that a percentage? Was that like 25%?
It's like a third down, I think.
Yeah, it was roughly a third.
Yeah.
And then the 2,500 is
Can you mute that, please? Thank you. Go ahead.
2,500. Scott, I think he had some tools stolen or maybe a vehicle stolen. So he asked me for a draw, a premature draw after his hangers finished hanging, and his hangers had done a good job. So I was, I was okay, cool. Yeah, I'll give him an early draw. I was fine with that.
I see. All right, give me a minute here. Here's where I'm at. Apparently a contract was entered into between Mr. Haas and Mr. Grimstead, Frolic or Grimstead, in which some drywall was going to be put up on one of Mr. Grimstead's property. Again, just reading from the contract, there was a number of things in here, including said it would take approximately 2 weeks to complete, probably less than 2 weeks, drying time, etc. This contract price of $7,918. So this kind of took a lot long, obviously took a lot longer for 2 weeks. My understanding from the evidence presented, Mr. Haas was on the job for 5 weeks and the job still wasn't done. For a variety of reasons, Mr. Frolic or Grimstead decided to look, I'm going to complete this myself. That a lot of that's based on his opinion of the work, apparently combined with the delay. Mr. Haas has now I want the full contract price, but on the other hand, he didn't complete the job.
And I was willing to take it
So
down.
ma'am, sir,
sorry.
I'm speaking now.
Sorry.
And so, but the job didn't complete, but the contract that was in, you used the term in breach, the contract wasn't complied with when you went beyond 2 weeks. People have certain expectations for when they want stuff done, and I understand you had some mitigating circumstances there, but on the other hand, when things drag on, or Mr. Grimstead, Frolic or Grimstead has the right to say, look, just stop this thing and we'll finish it out, which is what happened. So I'm not going to enter a judgment in your favor to pay you for things when the contract hasn't been completed. So basically, I'm fine in favor of the defense, and then the case will be dismissed, and then that'll be that.
Okay,
That's it. And you're both are free to go.
thank
I'm
you.
going to give this back to you. You're welcome. Good luck.
Appreciate it, sir. Just for the record, this is off the record. A few years.
Oh, no, it's not off the record. We
Oh,
can't
this-
be off the record.
Oh, this is about
And-
something completely different. You helped me out in the past.
Okay, I don't know anything
Okay,
about that.
okay,
And I don't remember anything. And-
Okay.
And that's,
Just thank you.
all right. You're welcome.
Have a good night.
You too.